people having far more expenses than they ever imagined, and in vulnerable individuals being taken advantage of. So that's why I do what I do. I want to make sure that we get to questions at the end of the seminar. So please write them down in the chat. At the end, Justin will read them out so that I can answer as many as possible. Of course, remember, I'm not your counselor. This is going to be a general Q&A for actual custom tailored advice for you. You want to make sure that you're in a confidential consultation, but take notes, okay? Take notes. There are some worksheets that we've got for you. This is interactive. I want you to come out of this really having a much more thorough understanding of not only estate planning, but the system that we have in place as a default by the state of Florida if something happens to you, okay? All right, so why do we do estate planning? Well, one of the reasons that estate planning is important is because for those families that did not plan, they end up paying this huge involuntary tax. And I call it an involuntary tax because if family can't get it out of an estate and it's stuck there and none of the loved ones have the funds, the means, the organization necessary to get those assets transferred to the next generation, then what happens is it is cheats to the state. It starts going to the state Department of, unclaimed assets, and that's $70 billion across the United States, well over $2 billion in Florida. And it's not because you don't care, right? It's not because your family members don't care. It's because simply they didn't know that there was a much better way to do things rather than using a will or not doing anything at all. So estate planning, generally people hear those words and they might think of a will, they might think of a power of attorney or some sort of documents with relation to healthcare. Sometimes they think of special kinds of deeds, but this is not estate planning, okay? That's just paper. It is just writings. And those writings can be phenomenal for your family or they can be horrific for your family. And the only way to know if you have something quality is if you're actually using an attorney that is very well versed in what they're creating for you, because the wrong tools are going to be, they're going to be dealt with in court, not so in a not so pleasant fashion. Okay, so many times you go out, you speak with your friend, you speak with your hairdresser, you speak with your pastor, and they say, oh, you need a will. But a will isn't enough. A will just guarantees that you go to court, because here in the state of Florida, wills must be administered through the court. They must be approved by the judge. And wills have zero protection for you if you're incapacitated. Okay, they only come into play if you're deceased and again, approved by a courtroom. They do not provide any protection with respect to taxes, with respect to creditors or lawsuits. Creditors come first in the courtroom. They definitely don't prevent money going into the wrong hands. We have some young adults that might be vulnerable or minor children that just don't know how to manage assets. For those that are business owners, yeah, a will isn't going to help support your business. So wills are designed to force your family into court. Forms are also not legal counsel, okay? So I don't want you to think as a power of attorney as legal counsel or a healthcare document as legal counsel. None of those documents, right? If you download a form online, they're not going to tell you who the right person is for the role. They're not going to walk you through that, or even if you chose the wrong person, they're not going to warn you about whether the choices you're making are going to result in really nasty tax consequences. They will not help you understand how to protect yourself from the wrong people during incapacitation. And they certainly are not going to prevent future lawsuits. Every single DIY form that I have reviewed has serious mistakes. And I don't want you to be failed because you thought this was the way to do it. Okay, so let's talk about some of those options that you have as human beings here in the state of Florida, or in another state that you might be living in. For that, please refer to local counsel. But your options are, one, doing nothing. Doing nothing results in you having to deal with the state's plan for you. And we're going to talk about what that state plan is later on in this webinar. You are also, again, you have the option of downloading online forms, which I've mentioned a few of the problems, the pitfalls. Or you can even use a non-lawyer, because guess what? There are plenty of people out there, financial advisors, insurance agents, CPAs, who think they have the ability to make legal documentation for you because they want your business for something else. Maybe they want to manage your account. Maybe they want to prepare the tax returns. Either way, they're engaging in the unlicensed practice of law, and anything created by them, you're not going to be protected against, because they don't have to respond to any supervisory agency, right? I have to respond to the Florida bar. They don't. Some people go to a door lawyer. What is a door lawyer? A door lawyer is a lawyer that takes any type of case that walks in through the door. They might be doing criminal proceedings. They might be doing family proceedings. They might be doing a little bit of personal injury here and there. And they also dabble in estate planning. These kind of lawyers have no idea the messes that they're creating. They're just hoping that whatever they created for your family is enough to have you have to hire them for the probate litigation after. You can also go to high volume firms. These are the ones that say, oh, we'll do the plan cheap. We'll do it for $1,500 or $2,000. Very, very quick. They give you a set of documents. They send you on your way. It's high volume because they require all their associates to complete a certain amount of documents per month to keep the lights running. But high volume means tired people. It means mistakes. It means that you're going to have a false sense of security. And it also means that you're probably going to get zero funding assistance. Oh, and funding we'll talk about later. You can also go to Big Law, right? So Big Law is the high priced up, law firms that you see downtown. Big Law can do excellent planning for you, but it is also coupled with a very excellent high-end price point. So they like to focus on families that already have taxable estates, and you're going to be charged generally between $500 and $1,000 an hour to do those plans. And then you can also do what? You can do legacy planning, which is what we do, which is what about 600, 700 attorneys around the country have been trained to do estate planning differently, to do it as something that is not a one-time event, but something where people keep learning about how to use the tools correctly. They actually make sure that assets are connected in the right way so they're not left out, they're not stuck in probate. Legacy planning is a completely different tool than what you are used to. I'll give you an example of some of the things that we advise our clients on. Not just legal advice, but also tax advice. And sometimes we work with their financial advisors on the strategy. How are those investments that they have going to work to support them in time of need, in time of incapacitation? We create legal tools that make sense with each other, right? It wouldn't make sense to create a will that says, and in the event that I pass away, all these things to these people, and then just completely ignores a trust that you created. We also have guidance for loved ones. We have a very exclusive handbook that we hand to our clients. It's a real book that allows for conversation starters between you and agents. It also provides helpful guidance on what to do during the first 30, 60, 90 days after a person's incapacitated or passes away. So it's protection not just for you, but guidance for those people that you've put in place that you trusted to do something for you and your loved ones, which is essential if you want something to function. So you might be thinking, well, is this something that's right for me? Listen, everybody can benefit from legacy planning. There are different firms that work on legacy planning for different individuals. Okay, so for example, there are firms that focus on the elderly community and kind of do a mixture of Medicaid and elder planning as part of their legacy practice. That's not us, just to let you know. We focus more on business owners, blended families, real estate investors. That's a really big one. So real estate related businesses. and couples with young children or young adult children. So think more of like if you're in the kind of Gen X, maybe elder millennial, or you're just starting your family and you have at-risk young children. That is who we focus on. That doesn't mean that we can't connect you to the right people, to trusted individuals and firms that really do things carefully. But I just want you to understand, legacy planning is for you. You just have to find the right practice to support you. So I want you to understand, we're going to do some exercises, right? I want you to come out of this with your brain having done some exercises, and I want to test right now how prepared you are. Because many of us think that we have wonderful plans in place or that we're heading in the right direction, but we might be missing things. So we're going to have 3 different participation questionnaires that we're going to go through to help you identify some weak spots and also to help you have the right kinds of conversations with family about where those gaps are and how you can help prevent chaos from those gaps. My team in the chat has just placed a link for your exercise form. So this is for you to be able to have answers to those questions in a confidential way. Nobody else sees them. Okay, this is for you to use as a tool to take to go speak with your husband, your sister, your mom, whoever it is that you're here for, because I know that you're not just here for yourself, you're here for family. Okay, here we go. Number 1, we're talking about incapacitation. What if you couldn't speak for yourself tomorrow? Okay, this is the reality of incapacitation. When you are incapacitated, you no longer have the ability to make decisions for yourself, to give instructions about what your needs are, to manage your assets. And that gap creates opportunities for the wrong people to come into play. So number 1, who do you think would care for you if you happen to be in a coma tomorrow? Now, some of you are going to say, oh, it's going to be my spouse. And then some of you are going to realize, oh my God, that sister of mine, that older sister that wants to run everybody's life, she would be the first one to raise her hand. Or my mom and dad would make such chaos for my husband, right? There's these realities and family dynamics that we can't ignore. Now, even if it was the right person in place, do they know where your assets are? We are very private people by nature. We don't like to let people know what we have, where it is, and so forth. But that's problematic if you're incapacitated, because if even the person that you want to play a role has absolutely no idea what you have in place as resources to help you, you're going to be quite stuck. Finally, right? Are these people able to really understand what your needs are, convey them to physicians? Are they the people that are going to have the money to step up? Because if you don't have the right tools in place to help these people help you, they're going to have to go to court. And court equals money, a lot of money, a lot more than you have ever imagined possible. I'm going to give you just a little taste of how expensive it is to have to go to court. I was hired as counsel to assist in an injunction in a probate case. Why an injunction? Because somebody got a power of attorney at the last minute from this gentleman that passed away, emptied out his bank accounts, and yeah, we had to request the court to come in to stop this movement, to make them return a vehicle that they had also retitled to themselves. Yeah, lots of fun. That little proceeding with just a couple of hearings cost our clients over $12,000. So litigation is not a pleasant place economically, okay? And courts don't care about what you think you wanted or what your family thinks that you wanted. It has to be effectively done in a legal manner that's going to be respected. Otherwise, it's not great. Okay, so exercise number 2. Some of you may have minor children that are dependent on you. Some of you might have elderly parents that you're taking care of. And what if something happened to you tonight? What if you were driving to the grocery store and the worst happened? So we have to be conscious of who is watching those kids or those elderly parents when we're not available. And if something happened to you, who would they call, right? If you have a short-term caregiver, they're not necessarily going to be knowledgeable about who to approach. They're very likely to call 911. And if 911 is called, your children then get pulled off into foster care until you're found and identified, right? They have to be safe with somebody. And you also have, right, adult protective services come and take custody of an elderly individual who needs care. Those are not the best places for these two vulnerable sets of individuals. They don't know where they are. They are completely uncomfortable because they're going to be surrounded by individuals that they've never met. And that confusion creates incredible anxiety for both children and elderly individuals who have become dependent on you for care. So if you want to know how to prevent that, that is an important discussion to have with your estate planning lawyer, because we don't want to put them in that situation. Even if you had the right caregivers assigned as well, do those caregivers, right, whether it's a long-term caregiver because you're in the hospital or because you've passed away, do they know about your values, about how the day-to-day structure is of taking care of these children or taking care of these elderly parents? And do they have the economic means to continue to provide the quality of care that you wanted to have for your loved ones? This is why it's important to not ignore this aspect in planning. We have people that depend on us too. All right, exercise number 3. We're talking about death here. So what would happen the day after you pass away? First of all, again, who is going to raise their hand and say, oh, I can handle this? Or who's going to have to deal with it as a default? Whether it's somebody that raises their hand that you don't want involved, or somebody that raises their hand that you definitely want involved, or somebody that gets stuck with handling everything for everyone, like my dear friend. 2 weeks ago, my friend's husband's father passed away that morning, and he was ill. It was kind of expected. And then she was driving home that afternoon, and her mother called her, and her father died suddenly. So she lost her father and her father-in-law on the same day. And now as she's mourning, she's trying to support the two moms because nobody else is willing to assist in getting these things administered. Nobody else knows what to even start with. So who steps up is important. And do they have the resources and tools available to do it well? Do they know where your assets are? That's another important one, okay? Even if you are the spouse that survives and you're handling things, you might have been the spouse that relied on the one that passed away to do all the finances, right? We have in couples different strengths. Some are like the partner that will do all of the finances, that knows all of the bills, knows what all of the investment things are, that kind of planner. And then we have the other one that might be like the very good emotional support, go-to, schedules all of the events, make sure that all the doctor's appointments are there, or does all the home repairs, right? We delegate these things between couples. But if your delegation was to the person who passed away and they were the ones that knew where your assets were, you can have a very challenging time. If you did prepare something, right? If you did have, let's say you had a will, do they know where it is? And I ask this because as a Florida law firm, we get included in phone calls and mass emails from many distraught family members who ask at like a ton of different law firms at once, are you the ones that prepared this will for my mom or my sister or my brother? They don't know who did it because they can't find the thing. Okay, very tough. And again, do they have the money to hire legal counsel if a probate has to be opened, which a probate, again, has to be opened if there was no plan in place or if they went with a will to be the plan for their system, okay? Even the right people as well can be blocked by courts, and this is because they might not qualify under the rigid legal standards that we have for somebody appearing in front of the court. So I want to ask you, are these things, after going through these steps, have you identified some gaps in what you have in place? Or maybe places where you might want to strengthen what you do have in place so that nobody is left in chaos. This is something that a probate judge told me. He says that there's so many times that he wishes he could tell the deceased person when he's facing, right, these families in probate administration, how much would you have paid the right lawyer to bring you back and correct this mess? Because the reality is you can't be brought back, right? Once the mess is there, it's there. There's no going back. There's no oopsie daisy or mulligans. That doesn't exist in the real world. And so now is the only time you truly have to make those corrections or to make that plan that is going to be effective for you. Let's talk about some of those mistakes that families make. Okay, so for example, they might make deeds that are joint tenancy deeds, and they think, oh, this is great. If I pass away, it goes immediately to this loved one. Wonderful, but you've added them to title with you presently. So one, it was a gift. They don't get the tax benefits of a step-up in basis because it was a life gift. Two, now you have the problem that their creditors can go after that asset because it's a present thing that they own. So yeah. Three, they can also object to selling the property, leasing the property, etc., because they are co-owners with you. And this can happen in life estate deeds. These can happen in joint tenancy deeds. Big mistake. Another set of mistakes that I've seen is sometimes in the documents, even if they have a trust, they name people to have the sole and exclusive role of trustee, and then they're the same sole and exclusive beneficiary. And under Florida law, creditors can kind of pierce through that. And what you thought was protected for the sake of your loved ones no longer is. There's also this perception between families that they have to make the older one the first one to administer things, but that older person might not be the right personality, character, not have enough understanding of financials to be the one doing that administration. These are real life problems that have affected many, many people that have come to my practice to seek legal counsel to help fix mistakes over 17 years. We've created a second tool for you. Okay, so the first tool was those questions regarding those three situations: your incapacitation, what happens with your dependents, and then what happens when you pass away. But now I want you to also take advantage of this legacy leak test. They're very, very easy questions. Again, these are wonderful tools for you to use in conversations with your loved ones to make sure that if you do have vulnerabilities, you address them. It also lets you know if you're the right fit for us. You might not be the right fit for us. That's okay. My job here is to be a counselor at law to the community. That's why I do these webinars. But I want to make sure that you take an opportunity to not end up the person in the halo that wished that they could have done something but has zero ability to fix things. If you do qualify for the legacy leak test directives, somebody that can work with us, let me tell you what we have in place. For tonight, because again, I'm a counselor at law, I need to motivate you to do something if you haven't done anything or if you've done barely anything. And this is my incentive to you tonight. Okay, I'm calling it a golden ticket. It's very easy. It's booking a discovery call with my team. If you're the right fit with us, wonderful, great. We can get you scheduled for a legacy planning session for far less than I normally charge. Or if you're not the right fit, my team might have some instructions on other people that might be a better fit for your needs. Okay. Remember, this isn't about me taking all sorts of every single person in place and, looking for the community to just, I'm going to do this and do that. And no, I want you to speak with the right legal counsel. My team also wants you to speak with the right legal counsel. This is why that's just a discovery call to see if there's a right fit between you and between us. But I want you to take at least the first step in making those corrections or improving what you thought you had in place. All right, so let's continue with what is the system like if as a default you choose to do nothing, right? The state's plan for you, this is the most expensive plan. So what happens if you become incapacitated and there's no plan in place? First thing that you need to understand, under Florida law, there is no automatic decision maker. There's no like, oh, I'm married, so as a default, it's my husband. No, that's why we had 15 years of litigation under Terry Schiavo's story, okay? It started out in 1991. It didn't really end until 2006. So there's no automatic decision maker. Stop that assumption. So what happens if there's some sort of disagreement between mom, dad, husband, sister, so forth? Well, at that point, you have to go to court because no one's decision is superior to the other. And the courts are expensive. The courts require a judge. The courts require a specialist to determine that this person really is incapacitated. The courts might appoint a professional guardian, not you, and professional guardians are not known to have the best reputation here in the state of Florida. There was a report that was done about, I want to say about 10 years ago, that found substantial abuses by professional guardians of the individuals that were incapacitated under their care. As a result of that, the state of Florida, the legislature created a system for reporting and hopefully actually disciplining these professional guardians. Recently, ABC Action News did a piece on that alleged, reporting system. They found that 64% of professional guardians had complaints against them, but none had any sort of disciplinary proceedings against them. So you don't want to rely on professional guardians. The people that want to be a guardian also have to go through background screening. They have to go through some training. It's about 8 hours for that with a grown-up. It's an additional 4 hours if it's for a minor. It can be very, very, very costly. And if a person ends up having a guardian appointed for them, they really do lose a lot of their rights. Something that doesn't happen if it's done through the private tool system. It can be very, very expensive. The other aspect of guardianship is, let's say you're the guardian, you've been serving your mom, your dad, your sister, your adult child for years, and now comes in a new judge. And they have a very different perspective of how you should be administering this for a loved one. This happens all the time, okay? Judges rotate fairly frequently, or if they retire, you're going to have a brand new judge come in. This is unsettling for many people because just as you start getting used to something, here comes an entirely different set of rules and instructions. The other part is you are stuck with court filings if you have to go through the court system, because every year you have to file an annual accounting and you have to file an annual care plan for the rest of the life that incapacitated person is around, right? Very, very, very expensive approach. I'm going to share a real story with you. So there's a Florida couple, they're my clients, their child went missing a couple of years ago. This is an adult child. That client told me that there was no plan in place for this adult child. They were about 30. And because they couldn't find their child, they couldn't handle anything on behalf of their child. They had to sue in court to get legal guardianship over that person. In a few months, they told me they spent over $35,000 in legal fees and costs to just become the guardians of their daughter. They've been having to report to court multiple times a year. They hate it. And they told me that their last year, with respect to just maintenance, the administration, after they had been appointed guardians, cost them $20,000. So the guardianship process is very expensive. What I want you to take away from this is it's not just like an elderly individual that develops Alzheimer's or dementia, which, by the way, you can have a diagnosis for that far younger than you think. It's the fact that being a young adult does not mean that you're not vulnerable, right? We could have mental health issues. We could have addiction issues that render us incapacitated. There's all sorts of reasons, but overall, we want to stay out of guardianship court. Okay, so now probate. Guardianship is actually under the purview of the probate court system, but generally probate is what we understand to be the place where you get to pass your assets to your loved ones. That's what's assumed, right? So if you have no plan in place or you have a will, probate has to be opened. A random judge gets assigned to it, and it's very slow and it's quite expensive. And it's also, to a certain degree, public, because these dockets in Florida are viewable by anybody. One of the most disturbing aspects is that there's first and foremost a creditor's period. And a creditor's period means that the assets really can't be distributed to any of the loved ones, even if they desperately need them, because creditors must be able to make their claims and they have to be paid out. So your family ends up getting what's called the residue of the estate, the leftovers of the estate. And if there's minors involved, you might have to do conservatorship proceedings to support passing along assets. And if you have young adults, bam, assets are given to them outright. There's zero guidance. I can tell you with confidence that an 18-year-old getting, 30 grand is not a good idea. It can be gone in weeks. I've literally had clients tell me that is the reality of what happened. So it's not a pleasant system. The courts also generally require bonds, okay? Even if you think that there's not a lot of assets, they can require a bond. So anybody that wants to serve is going to have to post the bond. And so they're going to have to rely on either having that level of assets in cash available to post it, or having enough qualifications to make a surety company happy so that they'll issue a bond on your behalf, but you still have to pay the bond issuance fee to that bond company. And those bonds can be a substantial amount of money. Recently, we've had an $18,000 bond for a case where there was just a house, just a house, nothing else. We had a $150,000 bond for a case that has some assets here in Florida, some in California, some in South Carolina. And we had a case with nearly $300,000 in bond, where it's mostly liquid assets. So again, it varies very much by the judge, but judges have absolute discretion in issuing bonds, and they prefer to require bonds, even if everybody said, please don't make us post bond. In probate, right, the probate system, you might actually be required to do multiple probates. Sometimes people don't realize that if you have a property here, let's say you have property in Pinellas County, Florida, but you also have an investment property in Duval County, Florida, and you didn't do proper planning, you're going to have to open up a probate here and in Duval County. So multiple simultaneous probates can happen, and they happen more often than you think. Your loved ones might not be able to afford paying a lawyer either a flat fee rate or an hourly rate to get started on this. They might need to go to a contingency lawyer, and contingency lawyers will charge a much bigger portion of the estate. Could be 30%, could be 40%, just to take the case on for your family. So that's an enormous chunk, an enormous legal tax that your family would have to pay out because you didn't do planning. And the other aspect that is really frustrating to families is that across courts, there's no consistency. Okay. It could be that like this one judge in Pinellas County has this way and wants the documents to look like this. And then in comes the next judge, same division, and they want things done completely differently. And now there's a delay in the case because, hey, different procedural requirements. The result is confusion, right? Exhaustion. Your loved ones might end up with very little cash for a very long time because they've put up all these resources to be able to get this case done, and resentment builds up. What if you have a trust? Some people think that they've planned because they have a trust in place. And let me tell you, the trusts can be phenomenal tools, or they can be horrific instruments that create a lot of heartbreak. Trust can fail as well. I've reviewed many trusts across years, and that picture you see right there with like the handwriting and the red and the marking this and the marking that, yeah, that tends to happen more frequently than I would like. Sometimes the problem is that people didn't put any assets into the trust, so they have an expensive paperweight. Sometimes there's clauses that completely miss what goes at all to the surviving spouse. There's sometimes cases where they just didn't update it to reflect changes in their family dynamics or family structure. And if it wasn't signed and executed correctly, it can all of a sudden disappear upon the death of a loved one. I don't want you in that situation, because then you get kicked right back into probate court. When trusts are ambiguous, when trusts are missing key provisions, your loved ones also then have to go to probate court under trust administration to see if a judge can and will edit something to make it manageable for your family. So don't just think that a trust is enough. Why does traditional estate planning fail you? And I'm talking about the ways that regular firms do it. Okay. That quick come in, pay $1,500 or $2,000 to get this done firm might give you 15 to 30 minutes of designing. They're not really going to have enough time to cover family dynamics. They're not going to address tax issues. They're very often miss real estate and businesses. It's not effective. There's also zero education or follow-up. Why? Because it's a one-time event, right? They do the documents, they give it to you, you go and put it on a high shelf, or very dangerously go put it in a safety deposit box that nobody's going to have access to. And that's it. There's no follow-up. There's no amendments. There's no edit as your life changes. Many of these law firms, okay, they're going to hate me for telling you this, have what's called back-end drafters. These are non-lawyers who they hired to do the drafting of these instruments for you. This is a frequent preference by firms that just want things done quickly. And they also have absolutely zero training available for the people that you put in place. So you get a lot of fights and you get a lot of heartbreak. And again, I don't like having to deal with that. Sure, half of my practice, we deal with it. We live and breathe that litigation chaos, but I would prefer you be on the planning side of my practice because you have control. So let's talk about those DIY kits and just the other traditional options, okay? These companies that sell you form online, they sell you forms without one care about the problems resulting from those forms not working for you. Why? They are not subject to disciplinary proceedings. They're just machines, right? There's no consequences for them. So if there's a mess up, it's not like you can go and sue LegalZoom for preparing something wrongfully for you. For those very high volume firms, those partners are forcing their associates to meet certain quotas. You're going to get very tired people working on your plan, if not done by a back-end non-lawyer. At the big law firms, young associates will get assigned to people that don't have those massive taxable estates. They're going to have to meet their hourly billing requirements, which usually require them to work 70 to 80 hours a week. Again, you're not going to get the best work product. There are some firms that, again, just literally will create the bare minimum document for you so that they can go and get hired for the probate when the time comes. I also add it's how it's always been done, because I've been I've been privy to conversations at these local bar associations where estate planning attorneys go, I can't believe that she expected me to explain the documents that I created for her. I don't have time for that. And today, in one of the estate planning groups that I'm a part of on Facebook, where there's other lawyers involved, here's something that a lawyer said regarding giving drafts to clients, right? I don't give drafts. Every time I do it, it just leads to an incredible hassle. Why do you think they say that? Because you're going to ask questions. And I think as legal counsel, we should answer your questions. We should make sure you're comfortable with what's there. We should help you understand what's written and why and how it works together. I don't see you as a hassle. Sometimes there's financial advisors, financial companies, life insurance agents that offer certain products, or they say, oh yeah, we have somebody that will create, like a basic will kind of a plan for you. And the reason why they offer these is because they want to manage your assets, right? They want your business, but it's not actually tied to the planning itself. So they're not going to give it a lot of care. It's just going to be the bare minimum and very cookie cutter. So overall, these things happen because they don't experience the harm. Your family's the one stuck in court. Your family's the one with heartbreak. Your family's the one that can't afford to transfer assets to loved ones. And these are the cheap methods, right? And we have a saying in Spanish, lo barato sale caro. Cheap is expensive, right? I don't want you to deal with the expensive litigation, because it's not just the expense. It's the anxiety, it's the uncertainty, it's the, I don't talk to my sister anymore, I don't talk to my uncle anymore, my mom doesn't talk to my brother anymore. That, I don't want you to deal with that. Our system, the legacy planning system, is a very nerdy, I love being a counselor at law approach. We help you track your assets. We have conversations regarding the risk of what you have in place, how it's titled right now. We help you plan your trust with some very tax-savvy ideas. And yes, you can have tax issues even if it's not an estate tax, because estates and trusts still have income taxes. And if there's a way to minimize those income tax issues, you should take advantage of it. Obviously, we talk about incapacitation planning and business succession planning, but we do this over a number of years, because I know that, for example, what I tell you tonight, you might forget 80% of it by tomorrow morning. So if I want to be a good counselor at law for you, and you want to be effective in what you're doing for your family, you are going to benefit from multiple years of support where we're drilling this into you, like those atomic habits. And we want it to become second nature for you to understand what the process is. That is a real plan. And yes, we say it's anchored by our used AAA framework. And this is just kind of like a little honorary to AAA. It saved me from running out of gas, my tire popping, all sorts of things when I was in college. So what is this used AAA system? Updates. We remind you, if there's something that changed in your life, you need to update your plan. Okay, not updating it will have not great consequences. Strategy, things need to be strategic. Things need to match up with your life and how the people in your life behave and the type of relationships that you have with them and how you want things to look in the end. Education, as you can tell, I am a huge nerd. My entire team is composed of very pleasant nerds. We like teaching. We want you to make informed choices. We don't see you as a hassle. Advice. We want you to come to us with those questions, with those uncertainties. For example, I had a client ask me, Natalia, I'm planning to do this business and how do I tie it into my trust? And, I had several follow-up questions like, how is it going to be taxed? And what kind of business is it? And, what state is it going to be formed in? All these things matter as to how you connect it with the plan that you have in place. Accountability. We make sure that you do your part. We call our follow-ups with clients lovingly nagging, but we have it in a systematic fashion. Lovingly nagging you about updating your inventory. Hey, you got a new asset. Hey, you got rid of this thing. Lovingly nagging you about funding your instruments, actually changing title to things, updating transfer on death beneficiary designations, all of that. We lovingly nag you to hold you accountable. And then awareness. Part of us being so nerdy is that we keep up with the law. Changes in the law, it could be tax law, it could be local law. But if you're not aware of those changes, again, your family faces consequences. We start out with a legacy planning session. So if somebody retains us or wants to have that conversation, it starts with the legacy planning session, and it is exclusively tailored to the person I'm having a conversation with or the couple I'm having a conversation with. That 15-minute call that we're encouraging you to do using the golden ticket, that's to see if you're a good fit for this session. And again, it's okay. You might not be. That's fine, but you're at least taking the next steps in understanding what might help you and your family. So legacy planning sessions are 90 minutes minimum. We have very deep conversations about your assets, about what's at risk. I ask a lot about your family and your health, and I'm issue spotting all along the way because I need to make sure that you're clear on the risks to you and your family specifically. I need you to be clear on what you can do to address those issues. And I'm going to give you a clear, flat fee for what you want to happen. The other aspect, of course, is that this is confidential, right? If you're meeting with a lawyer, it needs to be in a confidential setting. We want you to have informed decisions. And because I have an LLM in taxation, that's a Master's of Law in Taxation, I'm going to tell you about tax issues that exist within what you have in place that other attorneys just simply don't know. Okay, the majority of estate planning attorneys do not have tax training. And so they're not very good sometimes about advising you on a specific plan or strategy. Why? Why can it be painful? Because if you are stuck in probate, for example, right? You have to wait for the judge and the creditor's claim period and all of that to be able to pay the income tax return that's due. You might not be able to make the distributions that might be creating some deductions from estate income tax liability. Obviously, there might be estate tax issues too if you are at that level of an estate. But if your attorney doesn't know how to plan for these things, you're going to end up with something that's definitely not adequate. So again, your options. Your options today are doing nothing. They're downloading a form online or using whatever it is that your financial planner thought they could recommend to you, which is, again, the unlicensed practice of law. You could go to a door lawyer. You could go to the person that did your personal injury case and hope for the best. You can go for an estate planning firm that does high volume, but you're not really going to get much assistance after the fact. Big law equals big dollar bill payments, or you can go to a law firm that engages in true legacy planning. And again, it's not just me. There are other law firms around the country that do legacy planning. Find the one that's the right fit for you. But legacy planning is very, very different from all of those other systems. It's not cheap, but it's also not the most expensive. And it certainly is nowhere near the price of doing probate administration or guardianship litigation. A lot of families get stuck because they think these things are true. They think that estate planning is only for the wealthy. Okay, wealthy people have more liquidity. They can afford for there to be a mess up so that somebody has the cash to open up probate proceedings. But if you are part of the American middle class, working class, you might not have that level of liquidity. Your loved ones might not have that level of liquidity. Your assets are frozen if probate is necessary or if guardianship is necessary. And until you get permission to touch those assets, that's it. Sometimes people say, okay, my spouse is going to automatically get everything. I'm perfect. I'm all set. Not really. I was hired in a probate case about a year and a half after this particular client had already had another probate attorney. And he needed the house to pass a certain way so that he could pay for his cancer treatment. But even though he had been married for 35 years to his love of his life that died of cancer, she had a prior daughter, right? Daughter from a prior relationship. And because of that, he was never able to do anything with the house. He died 2 weeks after he retained me. So even though I was able to get an emergency hearing, he got nothing, no resources for treatment. And then, of course, people say, well, I can't afford this right now. Listen, things come up. We understand, okay? Your AC unit fails, something happens to the roof, there's a leak, but you plan for it. You use your resources to make sure that you're budgeting accordingly so that it can get done, because your family is not going to be able to afford probate and court fees or the actual family conflict that comes with it. Planning generally costs, less than 1/10 of the state's plan, and certainly far, far less than your family having to go to a contingency fee lawyer to take on the case. So again, this is the golden ticket. This is my incentive to you as an attorney to book your discovery call, okay? And reserve and have that legacy planning session if we're a good fit. It also lets you have access to our critical risk factor worksheet. This is not something other law firms have. This helps you organize yourself, organize your assets, maybe for the first time, organize your values, and address those things that actually are important to you. But I have a limited calendar. Why? Because I do take quite a bit of time with all my clients and everything that I handle. I don't like to do anything, as we say, half-assed. I like to whole-ass everything that I do. And so you can do that call. You can see if we're a good fit. You might be able to get into a limited session. We might have some openings this month, but I'm thinking they're probably going to go into June. It's important for you to do something for your family. Okay. Thank you. Thank you for coming here tonight and spending some time learning about a topic that's not really addressed in the public. You are a protector of your family, okay? You took this time on May 5th, Cinco de Mayo. You're not eating tacos just yet. So thank you for being around. We know that you can create a real plan for your family, that they can count on you, that you're going to take these questions and worksheets and have real meaningful discussions, because otherwise you wouldn't have come.